We heard of today's developments at the Royal Commission into Union Corruption, which is continuing in Melbourne. In recent days, the transport giant Toll gave evidence as a witness in relation to the affairs of the TWU. The Commission heard that during the 2011 negotiations for the Enterprise Bargaining Agreement, the TWU insisted on a clause that employees would be required to use TWU's superannuation fund, even despite employees wanting to have the choice to nominate their own fund. Broadly, though, the revelation of unions misusing enterprise agreements does threaten to expose the employers that have entertained union misconduct. Here to discuss the developments in the Royal Commission is our regular workplace law commentator, Joydeep Hor. Joydeep is Managing Principal of the specialist employment law firm People+CultureStrategies, and great to have you in the studio again. Thank you. So in terms of the evidence that was given by Toll the last couple of days, what do you think really was the new evidence out of that?
Yeah, I think what the focus of this inquiry has now shifted to is what role are employers playing, leave aside the more salacious issues that have been reasonably well known, I think, although perhaps not to the level of detail that has come out in the last few weeks. But what role have employers been playing in facilitating a lot of what was described in the lead up to the last election as dodgy union behaviour? And the particular evidence that's been given by Toll, I think, is quite alarming because it's not actually going to be that uncommon, I think, to find out that a number of employers have agreed to demands made by unions around the country as part and parcel of sealing deals when it comes to enterprise agreements that really should not have been terms that that employer should have agreed to. And what this exposes is, well, is that a form of corruption effectively that those employers, those companies, have been a party to or have been an accomplice to? And really, what leg do those employers have to stand on? Is their conduct any worse than the conduct of the unions who are asking for those particular or making those particular demands?
And so, say in that case of the TWU and what it did with Toll, is it clear whether that was lawful?
Well,
you're obviously raising questions about corruption. Are these things kind of clear-cut to someone like you?
Well, I think that there's a reality of what has been happening across a range of employers for many years, where if you are desperate to get a long-standing, protracted negotiation with a union across the line, that you do make concessions, you structure them in particular ways that ensures that at least it's not going to fall foul of the formal legalities, but really the effect of what you are doing is that you are not actually doing anything to benefit your employees, you are doing something to benefit the union of which they are a member.
And to keep the peace.
And essentially to keep the peace. Now, it all depends on perspective around something like this. There are a lot of employers who would say, and have been of the view that, look, our history is we've always had industrial action, that has cost us millions of dollars over the years as a result of the conflict. If this is what it takes to get this deal done, we know that we can then put it to rest for the next 3, 4, 5 years, however long it's going to be. Well, it's not as though we're paying money to any union official in a brown paper bag, for example. But what this kind of inquiry does expose is, well, you're not really providing any benefit to your employees, and an enterprise agreement should be about the terms and conditions of employment of your employees at your organisation.
And how far does that extend for you? I mean, I'm just thinking of one of the other cases, or one of the other bits of evidence given by Toll, which was basically they agreed to pay, a couple of $100,000 to put workers through a safety course that the company thought was totally unnecessary. They already had a safety course, but again, they said yes to the unions basically to keep the peace.
Well, that's right. I think if you were applying an audit perspective to that, you'd be saying, well, what is the actual legitimate cost of our employees or those employees going on a particular course? Would it really come to that kind of figure, or are we paying a significant premium because this happens to be a union-run course or a union-funded organisation, or what is effectively a side branch, a side arm of the union movement? And really, what is the appropriateness of that kind of conduct on the employer's part?
What about the restrictions on evidence and how that's probably likely to actually affect the hearing or hearings ongoing?
It's going to be very interesting because there's been a practice note that has been issued which has said that a lot of the things that we've become quite used to through this commission and inquiry process, whereby, say, an individual manager or person giving evidence could have their own barrister who is appearing on their behalf, who could effectively give them the opportunity to recover from some of the damage that might have been caused throughout the course of them giving evidence. The new practice note says, look, if they're going to be, if we're going to give them that opportunity, that's going to have to wait several months. And what the impact of that is that the damage, in many ways, in terms of the public eye, the reporting around the evidence that's given, is going to effectively have been done. And the recovery from that would ordinarily be allowed to happen through, re-examination, or call it what you will, is now not going to be allowed to happen. So we're going to see a lot of fallout, not just for unions and union officials through this process, but as the recent example with Toll suggests, there's going to be a lot of spotlight now shined on what employers have done, and things that they would not have batted an eyelid at for many, many years are now going to look really, really bad.
And there will be companies out there involved with the unions in question, the unions under the spotlight. Is there anything that those companies should be thinking, should be doing? What should they make of it all?
Well, look, if they're compelled to give evidence, they're going to have to give evidence. They're going to have to answer questions truthfully. Whatever they may have done in their past, they can't undo that. But I think at the very least, employers who have entered into enterprise agreements with unions and they have made concessions or agreements or commitments as part of that deal being done, whereby there was something that was agreed to that wasn't strictly about terms and conditions of employment, I think they need to be very concerned about that, because they will need to provide an explanation as to why they did that and on what basis they thought that was legitimate.
So do you think this is, in the end, like from an employer perspective, from your perspective, been far more revealing than you maybe expected to see?
I think so. I think that the fact that it started as something that was very much a Craig Thompson HSU type issue, and now broadening it into how employers and unions do deals, has actually shifted the focus away from what could have been seen to be an anti-union witch hunt to something that is more about how employment terms and conditions are negotiated and regulated, and that's broadened the scope more significantly, certainly, than I would have thought.
And in terms of the way you advise clients, I mean, is it just an approach, OK, let's go back to the knitting, like, let's be obvious about this, this shouldn't have been happening, yes, it has been, but let's just, take it back to basics? Or does it actually shift some kind of the advice, the conversations quite significantly for you, I suppose?
I think that the formal rules are quite clear, that in terms of what should be going into these agreements, it's pretty black and white. There's no way that a contribution of $150,000 a year to this kind of a fund could ever really legitimately be said to be about terms and conditions of employment of employees. I mean, you can run some cute arguments around that, but it's inventive at best. So I don't think there's any grey around what the rules have been. We all know, or certainly practitioners who practice in my area know, that the biggest challenge has for many years been getting the union to be on side with what you as an employer want to get across the line. That's the real test. Getting employees to vote in favour of it is not that difficult once they know that their union is telling them to vote in favour of it. So that's where you've had to channel your energy. So I can understand from an employer perspective why they buy peace or have bought peace in this particular way, but it's a brave new world now, and they can't get away with that, and certainly won't be able to get away with that in the future.
That's a really powerful message to, as you said, to employers. Not just the spotlight on the unions. Thank you so much, Joydeep. Great to have you.
Thanks, Brooke.
From People and Culture